I'm your host, Marc Stevens, author of Government Indicted. Glad to be with you here for this November 25th, 2017, live from the fortified compound in Mesa, Arizona. May 3rd through May 6th, 2018. Remember, we're going to have Libertopia 2018, libertopia.org, libertopia.org. Check it out. I know that they didn't do it for a couple of years, but it is back, and it's back at Humphreys on the Bay in San Diego. Wonderful. Wonderful. Oh, it's a beautiful area. Even when it rained, there was one time it rained a good portion of it. It was light. Still, well, not the whole time. Still a great venue, so looking forward to being able to go back to San Diego. And we'll also get a blues jam going. We got enough time to plan that, or plot it, with the guys from Barnwell Swift over there in Oceanside, California. So also hoping to be able to, maybe in a couple of weeks, before the end of the year, we'll be able to get back there for another live broadcast and blues jam. So, again, it's glad to be with you here. It's November 25th, 2017, almost the end of the year. Holy crap, 2017 almost gone. A lot of stuff to get to. We'll get to your calls. I don't like to bring people up on the first segment. It's just too short. But interesting here, I actually have... And if you're having issues with court, even if you can't join me on the show, definitely email or Skype me. You can email me at marcstevens@mail.com. We can talk about it. This one wasn't necessarily sent to me so that I could discuss it on the air. I just thought it was important enough to discuss it. I'm always interested to hear how these judges are responding. And so please send them to marcstevens@mail.com or call the show and let me know about it. Report about the crap that will spew from the mouth of these bureaucrats. A lot of what they say isn't just outlandish stuff that, we don't have to prove that. No, sometimes, there's a minimal amount of sophistication in their distractions. Because remember, if they had evidence, they would just provide it. They'd have just provided it years ago instead of trying to make these claims they don't have to prove. So we know that they don't have evidence to support the foundation claim that if you're physically in New Hampshire, then the rules apply. They're magical rules called law, okay? These are rules that apply magically. It's not just that they apply, but they also create obligations. So because we know that they don't have any evidence, they have to distract and get your attention away. And that's what lawyers do. They are masters at distraction, okay? These are the, spin doctors. And so somebody went into court. Where the hell did this happen? It looked like it happened in Jersey. And this was on November 21st. The judge, in a very condescending way, well, yeah, he's sitting 4 feet off the floor and has absolute immunity. So, yeah. I mean, he's got violent domination over people with no personal accountability whatsoever. No personal responsibility at all. Absolute immunity. Of course he's going to be condescending. He's ordered you to be there. He gets to order people to do things, and his orders are law. Legislators have to at least get together and have a consensus. They have to have a majority vote to create laws out of whole cloth. Judges, what they say is law until another judge higher up decides to knock it down. Of course you're going to be condescending. It comes with the job. Gee, violent domination with no personal responsibility. Really? Do you have to be a psychologist to understand that that's a recipe for disaster? I don't think so. So in a very condescending way, after calling my name up to the podium, say that, quote, I have looked at your motion to dismiss, and I'm going to deny it now. I don't agree with your interpretation of the U.S. Constitution. End quote. All while I was barely even at the podium. So I guess he was still on his way up, and this judge had to just put forth this crap. Then the prosecutor stated that the New Jersey State Trooper has not provided discovery as I requested it, and was seeking an adjournment on this date anyway. The judge says I can raise my motion to dismiss again at the future date. How do I handle that? Well, that's what we're going to discuss. I objected and stated that this court has no jurisdiction, no evidence that the laws apply to me, etc. The prosecutor just looked at me and the judge gave me a menacing smile. So now I wait for the next date. Wow. And he's asking about the scripts that we have, and they are available at markstevens.net. Use my the PayPal button or Cells. My Cells account is markstevens.cells, SELZ.com. Well, to get back, this is very interesting here because what the judge is doing here is raising a garden variety straw man. And for those who don't know, those who are new to the show, we do appreciate everyone, the new people tuning in. A straw man, this is from Wikipedia, is a common form of argument and is an informal fallacy based on giving the impression of refuting an opponent's argument while refuting an argument that was not presented by that opponent. One who engages in this fallacy is said to be, quote, attacking a straw man, end quote. The typical straw man argument creates the illusion of having completely refuted or defeated an opponent's proposition through the covert replacement of it with a different proposition, i.e. stand up a straw man, and the subsequent refutation of that false argument, meaning to knock down a straw man instead of the opponent's proposition. This technique has been used throughout history in polemic debate, particularly in regards about highly charged emotional issues where the fiery battle and the defeat of an enemy may be more valued than critical thinking or an understanding of both sides of the issue. Allegedly, straw man tactics were once known in some parts of the UK as Aunt Sally after a pub game of the same name where patrons threw sticks or batons at a post to knock off a skittle balanced on top. And this is what this judge has done. So those who are new, don't be thinking that, oh, if I file a motion to dismiss, the judge can just deny it and say something like this. I don't agree with your interpretation of the U.S. Constitution. So what should be done immediately here, and it sounds like he probably did, I don't think he raised the right objection, though, because he says I objected and stated that this court has no jurisdiction. Although it's right to say no evidence that the law applied, but you have to keep in mind we are raising in the motion the fact not that the judge has failed to provide evidence, but that the prosecution or the prosecutor has failed to present the evidence to support their argument that the Constitution and Code apply. So the actual straw man that we're talking about here is this nonsense that in the motion to dismiss, there is a discussion on interpreting the Constitution. We said that the prosecutor had no evidence to support his claim that the Constitution and Code apply just because he's physically in New Jersey. That's not the same thing as the interpretation of the Constitution. So that is just a basic straw man. We'll talk about that more when we get back. My name is Marc Stevens. Listen to the No State Project here on LRN.FM. We'll be back in just a moment. Talking about straw man fallacies here on the No State Project, where you go to court, you talk with bureaucrats, you are going to hear a lot of them. So it really does help that we know how to identify these and be able to object appropriately when they do come up. So we're talking about someone in Zia in Freehold, New Jersey, going to court there, and he had filed a motion to dismiss, and before he was even at the podium, apparently, there's a hearing, I should put hearing in quotes, by the way, on November 21st, and the judge, in a condescending manner, of course, stated, I have looked at your motion to dismiss and I'm going to deny it now. I don't agree with your interpretation of the U.S. Constitution, which is really interesting it's not the argument that was raised. The argument that was raised, or the position that was taken in the motion to dismiss, which is based on lack of evidence, because you file a motion to dismiss or a demur if you are in California or Kentucky, because the prosecution has not provided sufficient facts to set forth an offense, and cannot prove, and does not have sufficient facts to show jurisdiction, which of course is based on, if you're physically in New Jersey, then their constitution laws apply. And I don't think we're even talking about the U.S. Constitution. We're talking about the New Jersey Constitution. So one of the things you can do there is say, well, objection, are you sure you read my motion? I don't think, where in my motion am I going through the interpretation of the Constitution? And obviously, to make such a gross look, if we try to give the guy the benefit of some doubt over here that maybe he was honestly mistaken, no, you can't really give much credibility there, because there's nothing in there about interpretation. The closest you could say to interpretation, and it wasn't even the U.S. Constitution, really, it's more of the state constitution, because that's what they're charging you under, is the New Jersey Constitution, is that under New Jersey law, under their constitution, just like the U.S. Constitution, you have to have a valid cause of action. You have to have a valid case of controversy before the court can have subject matter jurisdiction. So even if you waive personam jurisdiction, which is still, if you're physically in New Jersey, the Constitution applies. So even if you waive personam jurisdiction, you can't waive subject matter jurisdiction. And those are direct quotes from the New Jersey Supreme Court. So it wasn't our interpretation of the Constitution. It was what the Supreme Court has stated about the case and controversy clause. So, yeah, you can object to something like that. Say, objection, where in my motion, give me the line and page number where I am arguing the interpretation of the Constitution, because I don't see that. Can't see that. Because, again, the motion to dismiss, if you're going to defeat the motion to dismiss, there's only two possible ways to do that. One, you have to show in the record already the evidence that is supposed to be there proving jurisdiction and a valid cause of action exists. Which, of course, you have to show a legal injury. You have to show that the Constitution actually applies just because you're physically in New Jersey. You have to have evidence. Or you have to show, this goes back to that Wisconsin dismissal last year or 2 years ago. You have to show some valid, rational justification why the prosecutor does not need evidence to support their claim. So that's it. Just saying the prosecutor doesn't have to prove that is not a rational basis. That's just because you said so. It's proof by assertion. I'm just going to say it. There's that Latin phrase. It's just the wind and nothing more. And here the judge clearly is trying to get away, and did get away with using a straw man. And just because we object doesn't mean that they're not going to get away with it ultimately. Yeah, of course they can. These are criminals. They do business at the barrel of a gun. So, but that's an objection that could be made. Look, it's just like when they say, like they did up in Tiffany Castillo, up in Concord, Massachusetts, that the evidence proving the Constitution and code apply, because Eric is physically in Concord, or Massachusetts, is in the complaint. Well, cite it. I guess you could ask a question before it's in the complaint. Are you able to cite it? Really? No, can you? Of course, they'd like to say, well, get an attorney to explain it to you, and you need to object, object and say, excuse me, I don't need, look, just identify it. Whether I can understand it or not is still up for discussion, because I don't even know what you're talking about. So why don't you just wait on your condescending scumbag comment about my intelligence that I need a lawyer to explain it to me. And first identify the subject matter so that it can be determined whether I can understand it or not. But identify it first. That's, the condescending way. Yeah, judges are criminals. They wear stupid black robes. They're crooks. And they are condescending because they can get away with it. They can do literally whatever the hell they want. When they are sitting on that bench with that robe on, cops will not touch them. Another judge that sits above that judge has to tell and give them the orders, because that's what cops do. Cops follow orders. Cops give orders. They may not understand them, but that's all they do. So here you just remember, when they say something like this, you have to be able to identify whether their response is responsive. Are they actually addressing the argument that you have raised in the motion to dismiss? And here, I don't agree with your interpretation of the U.S. Constitution. Objection, sir. What does that have to do with my motion? Did you read it? Probably after his objections, why he's saying it's unusual, and he said that he can raise the motion to dismiss again at a future date. I would say, and so he's asking here, how do I handle that? I would ask him to cite where in the motion to dismiss he sees an interpretation of the U.S. Constitution that is yours. Yeah, I know I go into there's a section there that it's unfit for adjudication, and there's a quote from the U.S. Supreme Court in U.S. versus Poe. I think it's the Poe case anyway. And the U.S. Supreme Court, it's not an interpretation, it's a direct quote that no complaint is fit for adjudication unless it sets forth an actual antagonistic assertion of rights. And there has to be evidence to support it. That's not an interpretation, that's a direct quote. So anyway, we're going to be back in just a moment here on the No State Project. So we got a lot of stuff to get to, so don't go away. And we're going down under to Brisbane. And we've got Kevin. Kevin, welcome to the big show.
Thanks, Mark. It's good to be on.
And you have that right. You're from Brisbane?
That's correct, yeah.
All right. So what's going on today?
Just ringing up. I've contacted, for following your example with your calls of shame going to different government departments and agencies, just asking for the evidence of jurisdiction. So whether it's a tax act or the Constitution, and going from different department and getting shuffled around to try and find this elusive evidence of jurisdiction, and I haven't been able to find it, even going all the way to the Federal Attorney General's office in Canberra, and speaking to constitutional lawyers there, and even they can't provide evidence.
So it's not Canberra?
Oh, Canberra.
I know. I was just taking a piss out of my American audience.
Yeah, and same like Melbourne. Melbourne.
Yeah. So walk us through a list. I would just throw out that I wouldn't necessarily focus on a particular law in question, because it kind of gives them a way of just discussing the text of the question of the law, and that's why I found it was better to just go to the foundation and ask about their constitution and leave it at that. So, have you done that?
Yeah, I have, and basically when I've asked, particularly say if I'm talking to the tax department over here, it's the Australian Tax Office. So first I ask them, I don't ask them how does the Constitution apply. I ask, what evidence do you have that the tax acts apply? And they obviously come back with, well, it says so in the Act, and the circular logic that you've discussed on the show numerous times. And then it ultimately goes to the Constitution. And then when you work out, okay, well, what evidence have you got that the Constitution applies? And obviously they're not versed in that, so they've got no evidence. So then they've got to basically say, oh, we've got no evidence. I've spent like countless hours with different people talking to them within the ATO, and like I said, even to the Federal Attorney General's office, speaking to constitutional lawyers there regarding the Constitution, and you're just using the Socratic method of asking questions, and rather than making any claims, and you get to the logical fallacy to the point where that they have no evidence, no matter how good they are, even as a constitutional lawyer. Just by asking questions, you can get to the root of the matter where there is no evidence.
Yeah, I'll give them this, that as a constitutional lawyer, they're probably really good at what this judge in New Jersey was strong, the straw man he raised as far as constitutional interpretation and what the courts have determined on certain provisions of the Constitution. But as far as being able to prove it applies, no. Have you? They of course you're setting them up for failure. Has any one of these bureaucrats actually admitted that no, I can't prove that?
Yeah, a lot of them have, especially the lower level people, as far as that they're so. I suppose, compartmentalised that they only do their job and they've got no idea of what's going on above them, so to speak. So you get to a point where they can't even get their head around what you're asking. They say, well, it's the law. It applies. You're here, so it applies. And it takes a long time for them to even try and understand what you're saying. And it gets to the point you go, well, can I speak to your supervisor and your supervisor to get to a point where someone can actually understand what you're talking about. And then, I've had one from the Department of Roads that says, we don't need evidence. We've got cops and they'll come around and they'll arrest you if you don't have your, and other ones as well. So there's been quite a few people who've said, no, well, not necessarily that they haven't got the evidence, but they're not sure how to answer the question. Then they'll refer me to someone else. So recent episode with the Australian Tax Office, they haven't been able to provide evidence to the point where they've sent something back, and I've gone through all the hoops regarding like public rulings and all the things. Private rulings to try and get that evidence, and then basically when I've pushed them to the point, I've received a message saying that the private ruling or the matter is now closed because. Basically, they're saying that it's not the job of the ATO or the ATO staff to provide evidence that the tax law or the Constitution applies. So they've got like a get-out-of-jail-free card where they're applying the law, but they within their policy they don't have to explain or show the evidence.
Well, and look, and this is a very common retort from these people, and what I say to them is, well, again, leading questions when we're doing this, right? It's like, well, wait a minute. You don't have to comply with due process and be fair? Well, of course we do. Well, doesn't due process require you to actually know what you're talking about, that you're making a valid claim against somebody before you take their property? Isn't due process at a minimum that you actually have a valid case before you accuse somebody of something? So that usually is a good question to bring out, that yes, they actually do have to have evidence. They do need to know. They just don't want to admit that. So you could even ask them too. So in the course of your job, you are part of the function of your job is to make false statements against people? Well, so don't tell me that you don't have to have evidence then. But we're using the questions to bring that out. But
yeah, that's right. And I'm not sure if you had a chance to listen to the audio that links that I sent you regarding the dialogue that I had with the ATO person. That 1.5 hour long.
I have not. I got to hear part of the beginning of one, but because I have family and it was that kind of, it was a holiday this week in the U.S., I didn't have an opportunity to hear it all.
Okay, yeah. So basically, it got to the point asking questions not only for evidence of jurisdiction, but every time she would mention something, I would expand it out to say, well, if I did this or if I did that, would that be criminal? And then they'll say, well, you're not government. And then we'll take to the next level as far as, okay, well, what evidence you're saying that government can do these things? And it got to the point where it was basically, well, what if there was no evidence? What if, the government is just all a big legal fiction and we still were taxing you? So basically it was sort of like, what would you do? And I said, well, what did you want to happen? And I said, well, if there's no evidence, surely that for the ATO to actually tax me, to lawfully or legally tax me, then surely then the ATO should then stop paying tax. Oh yeah, stop making me pay tax. And she said, well, that's not going to happen, even if there's no evidence, even if the court ruled in your favour, we're still going to tax you. So the criminality is there. So
wow.
Yeah, it's so, if you listen to it, it's so blatant that they don't care if they have evidence or how they terminalise with their terminology and that type of thing. They don't care the criminality. And even if I mentioned, well, if say another, because she brought up about stuff about, oh, well, taxes are there for, to do good in the community. And I said, what would happen if the Salvation Army used a business plan like the government and forced people to pay them money? And if they didn't pay them money, then, they'd lock them up or fine them and all the rest of it. Would you consider that criminal or wrong? And she actually didn't want to answer. She said about, I don't know if that would be criminal. So her whole...
Oh, God. Well, hold on, mate. We've got to... We're up against the break, so just hold tight for a moment. My name is Marc Stevens, talking with Kevin from Brisbane, and him questioning using the Socratic method to ask for evidence that these bureaucrats have, that their rules actually apply to anybody just because they're physically in Brisbane. We'll hear more and get your calls in just a moment, so don't go away. So Kevin from Brisbane, what I wanted to bring out, too, is... Look, judging from how long a call you're having from what you're saying here, if I could throw in a critique here, I think, at least in my experience, it's been better to really stump them very quickly. Is one, you get their position off the bat, so you know that how they're looking at things and why they think their Constitution applies and their sacred rules. So that's why I always ask, you operate under the presumption that if I'm physically in Australia, that your Constitution and laws apply, right? So get that out of the way. Then it's just a matter of challenging with leading questions that position, and it usually goes. It's more difficult for them to get into to have the things to start branching out, so to speak. So you start getting into these other issues.
Yeah, that's right. And normally I do try and do that. And I was surprised the call actually lasted as long as it did. But I wanted to also, it wasn't so much about the evidence of jurisdiction, but also to show the criminality of it. Even if they go, I'm not sure what the evidence is, but every time that she would say something, and it's not just her, it's other people as well, just to get to expand on what they mean, as far as to bring up the logical fallacy. They go, well, you're not allowed to steal and you're not allowed to make laws for other people, but government can, and sort of like, well, why? And you break it all down, and it expanded all the way out, and it just shows the criminality. Like I was saying before, when I was asking her about, would it be wrong for the Salvation Army to use force to force people to pay them? She said, I don't know if that would be criminal or wrong. And then...
yeah, okay.
So I said, you don't think it would be criminal or wrong for someone or an entity or group to use violence to force people to pay them money? And she said, oh, well, you didn't say violence. And I said, well, how are you going to force someone without using violence? And she said, well, we don't use violence. And I said, what happens if you don't pay tax? She goes, nothing. I go, nothing? And she goes, oh, it's not as if we're going to go around to your house and break your legs or anything like that. And I said, well, what happens if you don't pay tax? What does the ATO do? And they say, well, we don't use violence. We send out maybe a letter. And I said, well, what happens if you don't respond to the letter? Well, we'll send out another letter. And I said, what happens after that? Oh, we might get a summons to court. Or what happens if you don't go to court? Or you'll get another letter to go to court. And I said, well, what happens there after that? And and then she goes, oh, I know what you want me to say. You want me to say that the police will come? And I said, well, is that what happens? Oh, do the police come? And so it's basically, it got down to the point where, well, still not violence. And I said, well, how do the police get you from your house or from wherever you are to the court? Don't they physically use violence? And then that's when she went on almost a tirade. It goes, what if we do use violence? What if we, if there was no evidence? What if, blah, blah, blah. And it got to the point where she was basically saying, even if everything was criminal, basically what would the people do? the Australian people do. Like, she was so arrogant and, fine in her position to know that they were probably acting criminally, and the people would just sit there and take it.
She's got a point, I mean, they're arrogant, they're criminal, and it's like, okay, even if all this is true, that we're a criminal organization, what do you, it's like, I can't remember off the top of my head what Napoleon said, but, someone's got a problem here, let them tangle with me. Sure. And honestly, at this point in history, what would the Australian people do? I think a question that I didn't get a chance. I kicked myself because I wanted to ask this question to the Canadian professor of law, Robert Diab, that, well, if it is just a blunt assertion of power and it's not based on evidence or argument, then wouldn't we be justified in using self-defensive force to stop a tax assessment? But I think what we can do to shortcut a lot of what she's saying there and bring out the obvious contradiction is to ask him straight up. Maybe you've done this with some of them. If I was to act as your organization does and I forced strangers to give me money, would you consider me a criminal? And of course she's going to. And that's when you can then say, isn't that what your organization does then? So isn't it still criminal when, and wrong or immoral when you force perfect strangers to give you money? And then you can bring out, well, isn't that a double standard? So it's not okay for me and any of my neighbors to do it, but it's okay for you. Isn't that a double standard?
Yeah, and I did bring that up a couple of occasions, and I'll tell you, what if I was to do that and go and rob people and that type of thing and do this? And she said, well, you're not government. And that's where I brought up, well, how does government get its authority and jurisdiction? But I didn't actually necessarily point it out blank range that isn't that a double standard? I thought she could obviously see that it would be a double standard, but obviously she didn't care.
Well, but you bring that out in you asked your leading question about that. Well, wouldn't that be a double standard, that it's wrong for me but not wrong for you? And what is really great, especially since you've got some background, in the conversation now where she's admitting to no evidence, where they've said to me that, well, we can do this because we're the government. And I said, oh, that's because you have a constitution that authorizes it? And she said, well, yes. But didn't we already determine you have no evidence whatsoever to prove that that's applicable in any way? So you actually don't have the Constitution. So the fact that you don't have the Constitution authorizing it because you have no evidence isn't your action just as immoral and wrong as mine if I'm forcing people? Then they try to say, well, he's going to build a road. But so it comes down to, you can negate how grossly immoral an action is if you do something nice for your victim. Is that how it really works in your world? So I can go and I can actually rob your treasury, and if I give that money to contractors to fix potholes, it's not a crime, it's not wrong.
Yeah, exactly. And I did bring that point up with her as far as when she brought up, don't we care for the aged, and don't we do this and don't do that? And because I brought up the question of being unjust, and she said, is that unjust? And I said, well, it's unjust if your methods are unjust. And that's when I sort of went on to dissecting the criminality and the violence behind what they were doing. It's like, if we can't do this, and we shouldn't be able to delegate, being able to rob someone or make a law for someone to like somebody else in government. So this whole power thing where the government say, well, the power comes from the people, but the people don't have that power to give in the first place. So.
Well, yeah, and a good follow-up leading question to that is, so you're saying that the people that are forced to give money, those same people you're saying, that they're actually agreeing? Please. I love asking. So you're telling me that there's actually a principal-agent relationship between the government and the people? Really? The same people that are forced to pay? And obviously, anybody would have a brain in their head is going to realize you can't possibly have a principal-agent type of relationship when you're being forced.
That's right. Yeah. And I've had the discussion with people who, believe in the straw man all caps name, and they sort of say, well, you consented and it's a document and you contracted. And it's like, well, is it really a legal document if there's violence behind it? Isn't that extortion and coercion and all this type of thing? So some people go, well, you consented, but it's like, well, there's a gun there saying if you don't do it, I will do some other harm to you. And they know these people are criminals, and they don't like the whole thing because they like to go back to the Constitution. They're doing things unconstitutionally and all that type of thing. They know this, current so-called corporate government are criminals, but then they know the gun is there, but then they say that we consented. So it's all these, logical fallacies in their head that, I try to talk to some of them, and they can't get around the fact, a lot of them, that, there's no consent if there's violence behind,
Sure.
behind the threat.
Yeah, this stuff is going to take a long time to put to bed. I do when I do the show on Wednesday, and yes, I will be live this Wednesday. When I do the YouTube stream, I tend to get a lot of sovereign types and freeman types who insist that it's a contract and that there is evidence to show that they are using the old cap's name as some kind of set askew trust, and nobody can produce any actual evidence. I like to see that. Hey, it's been a pleasure talking with you. Hey, I will do my best to listen to those, and hopefully we'll hear back from you real soon. It's the second hour now of the No State Project, second hour of 3. It's November 25th, 2017, live from the Fortified Compound in Mesa, Arizona. Remember, May 3rd to May 6th, 2018, Libertopia is back, and it's back at the Humphreys by the Bay. Wonderful venue. Really looking forward to coming back. I will be speaking, and we will almost definitely have some blues improvisation taking place. That was really cool with... going back to the guy's bill over at the Living Tea Brewing Company and being able to trade licks, so to speak, with a harmonica player. I mean, he's pretty good with the harmonica, so that was fun. That was a lot of fun. So May 3rd through May 6th, 2018, and hopefully we will be able to get back on a regular basis to the Living Tea Brewing Company on Wisconsin Avenue in Oceanside, California. But you can sign up for Libertopia at libertopia.org. Appreciate everyone's patience. Real quick, just wanted to point out, back like what Kevin from Brisbane was saying, and I have many bureaucrats saying this. I actually have Scott Bales, the Supreme Court Chief Justice here in Arizona, saying it on video, that the evidence that their laws apply are the people that they've put in prison. And I like to just point out that kind of a common thread with serial killers is they have basement prisons. So, yeah, although Marc Dutroux did have a lot of government support, there's no doubt about that. So you can, so if you're not familiar with that, look up the Dutroux affair. Oh man, there's some sick stuff going on there. God, and you talk about solid evidence of government cover-up. Marc Dutroux. We only share a first name. Dutroux. Real horrible stuff. Evidence showing a massive government cover-up and conspiracy. Even better evidence than the Franklin cover-up. But the evidence is there nonetheless. New caller. We have area code 513. You're live on the No State Project. What's your name? Where are you calling from?
Hello?
Yeah, you're live on the No State Project. What's your name? Where are you calling from?
Hi, I am... this echo, I'm sorry. I'm calling from Cincinnati, Ohio. My name is Kim. We have a situation here. My entire family practically has a situation here in Ohio. We filed quiet titles in the process of adverse possession. We've had different outcomes for different cases. 2 were dismissed voluntarily. 2 have been set for trial early next year. 2 are in appeals court.
Jeez.
So I have myself and then 4 of my children, adult children, that is. Well, we've been going through this gamut of making it happen. But suddenly, I had a court case where I had a judge that was, I guess, pretty favorable in terms of, moving us forward with just the whole common law thing with the adverse possession. And I was really excited about the outcome because he's the judge that set the trial for January. There were 2 banks that were on this particular case, and he dismissed them from the case. They didn't have any interest in the property, real interest.
Okay, but before we get going, I'm counting at least 5. Does this involve 5 properties?
Yeah, 6 altogether.
Oh, okay.
Yeah.
So, okay.
But these were with different people. Okay, let me think. What was I saying?
I'm sorry I jumped in.
Okay,
It's just that I want people to understand that a quiet title action is where you're trying. 2 or more people are claiming to have rights to a particular part of a piece of property, and so you go to quiet that title and to figure out who has evidence to show that they are the owners of the property. So not everybody may know that. So I apologize for jumping in, but.
No problem.
It's necessary.
No problem. I appreciate you for having the call. When I had the success with that case, we went home and we discovered that one of my daughters had a indictment and a arrest warrant against her. So we were trying to figure out, what was that about? We're trying hard to figure out. Well, no one's done anything illegal, so how's this happening to her? Then my son just happened to look on the court dockets at his case, and he saw he had the same thing. And then I looked and I had it. So all of us now have this arrest warrant issued against us, and they've consolidated all of the cases, and they've created this criminal case.
What's the charge? What are the charges?
Really, really interesting. Tampering with records, unauthorized use of property, and theft. None of that could possibly relate to anything.
Well, just what I know, if it's a quiet title action, I can certainly see where somebody, especially if they know someone on the inside, that if it's in a quiet title where it's tampering with records, who were the defendants in the quiet title? Who?
Well, these were people that had abandoned property, so they were. Defendants, the former property owners, but they had not come forward because the properties are abandoned. So either they're deceased or have just decided to move on or whatever, but they have not filed an answer. There's only one in particular that did file an answer, and this guy alleged to be a part of an organization. The property was owned by an organization. Since he filed an answer, he has died. And in his very obituary, it states that he was an administrator for that organization. He wasn't a board of directors, so he didn't have interest. But based on him filing an answer, and, he was really just fighting the entire situation. The property had been abandoned for many, many years. He had taken money out on the property, didn't pay it back. It became dilapidated during the time that, he could have taken the money to bring it back up to speed. It was blighting, a nuisance. So after sitting there for 15 or so years, we stumbled upon it and decided that we could put it to use for community work. So him objecting to that, he had first taken me to court to try and get me evicted from the property, but that didn't work out in his favor because he wasn't the owner. And the court at that point asked me to prove that he wasn't, and I told him it was his job to prove that that wasn't my job to prove it. So after that, she decided, well, you're right, and we're not going to be able to evict her. So that was that. But then he went and apparently filed a police report or whatever, and then died after that. So it's like, I don't know. It's just a crazy situation. But what we're interested in knowing is when you have a situation like this, where this is just completely unjust, they've taken civil complaints and compiled them and created this one criminal action, and we're now dealing with these arrest warrants. So I'm concerned with, we've investigated a writ of mandamus and a writ of prohibition in terms of getting them to, take away this arrest warrant, and then getting them to put them back in trial court so that we can continue with the cases, in the proper venue where they were initially.
Well, it's way premature, I think, for the mandamus or prohibition. My first inclination here is I would file a motion to quash the warrants and a motion to quash the indictments. Right. We're up against a break. So Kim, just hold on. We're up against a break. Let me mute you up. My name is Marc Stevens. You're listening to the No State Project. And just for Dan, who just happened to have missed this, I mentioned what a quiet title action was. That is when you have two or more people disputing the rights to a piece of property, and you go to court to lay down and put the evidence on the table to see who has the actual, valid possession of the property. But we'll be back in just a moment. Don't go away. And just to give another... from Wikipedia, an action to quiet title is a lawsuit brought in a court having jurisdiction over property disputes in order to establish a party's title to real property or personal property having a title of against anyone and everyone, and thus quiet any challenges or claims to the title. This legal action is brought to remove a cloud on the title so the plaintiff and those in privity with him may forever be free of claims against the property. Yeah, right. Forever be free. So I want to bring Kim back up because that's what we're talking about here. Question before we continue on this. Has the trial judge found that you and your family have committed fraud on the court?
No, not once, not with one. All of us have different judges, and none that hasn't come up with any. The one judge that has consolidated at the prosecutor's discretion, he's the only one that had a little bit of a problem, and that's the one where the person who was previously a board of director filed an answer. He had counsel to file an answer.
Okay, so
that particular.
Okay, but for how did you get title to these properties?
Well, we don't have title. We just have possession. We have equity. We've done work on the properties, and then depending on the different properties, the different situations to occur.
But how did you initially get possession of the property?
They were just abandoned. They were blighted, abandoned property. So they were vandalized. So there were broken windows, doors. Locks broken, pipes missing, things like that. They weren't really, really nice properties or anything. You had to put sweat and equity in them to bring them up to make them livable. Okay.
And I don't, if you don't want to answer this, why go after these properties though? Why go in and do any improvements on them at all?
Well, it was my understanding that if you acquire property that way, then you can make it your own. If you approach it in that manner, that it will become your property. And as a result of that, number one, you're sustaining your own needs for yourself and your family. Number two, you're improving the neighborhood. I just saw, just positive.
Well, if it actually, it seems to be fine because, except for one of the properties, they have actually been abandoned, and whoever may have owned them is not making any kind of claim, and no one's contesting your actual claims. Now, as far as the records, that tampering with records, and what's the other charge? Tampering with records and what?
Theft and unauthorized use of property.
Oh.
When we research unauthorized use of property in Ohio, it is basically talking about computers, data, software. It doesn't talk about real property. It doesn't speak on that at all. In fact, we've never been hit with any trespassing. Like I said, about previous owners haven't said anything. They're not on a scene. So I'm not understanding how they're taking these civil complaints. Here in Ohio, it's Ohio Revised Code 5303-1, which gives you the right to file a quiet title. It says that a person with a claim or with interest or a claim of interest has the right to file this quiet title. So it's common law, but then it's also statutory. They have it in the codes. So I just don't understand, how do you flip it? How do you make a civil action a criminal action?
Well, they're not converting your civil action into, they're actually accusing you of violating their criminal code with tampering records, theft, and unauthorized use of property. So even if you take out the unauthorized use of property, the tampering with records is interesting, and then the theft, it seems pretty obvious. But what are they saying here? What are the actual allegations? I mean, have you read the indictment? Do you know what they mean when they say tampering with records?
Nope, that's all it says. There was a lawyer I was speaking with just over the phone, and he pulled it up. And what he said was that I'll probably need to file a motion to get clarity, to find out what they're talking about, because it's, not really detailed at all.
So they didn't lay out enough evidence in the indictment so that you could make an intelligent. So, well, that's actually, I wouldn't file something like, I would just put that in my motion to quash the indictment, that aside from the lack of evidence proving jurisdiction or whatnot, that the indictment is just too vague. That even if there was evidence of jurisdiction, the indictment is just too vague. With do you have other? When you were taking possession of these houses, did you have other? Did you have another home?
Well, initially, yeah, but when we were renters. But when you acquire that property, then, that changes. Once we were able to get it up to speed and make it livable, they're actually quite nice with the work put into it. We have before and after photos. We've actually done a very good job, in my opinion.
Has anybody in the neighborhood actually complained?
No. We helped to bring the neighborhood up. No one has complained in the neighborhood. And that's what I say, he doesn't have any evidence, of anything being criminal or anything being, done wrong. I just don't know. But I personally thought, based on the fact that in that last court hearing, that judge dismissed two of the banks. The banks are, it's just complete fraud, what they're doing. And I challenge that. I was able to do it in the motion or in the complaint rather, because I'm not on the mortgage. I'm not the homeowner that went into that contract, that mortgage contract. So I'm not prohibited from challenging the interest, all adverse interest, through the quiet title. So in the process of doing that, the banks were dismissed, MERS and Wells Fargo Bank. And there's another bank on one of the other properties. Only two of them had banks associated. The other bank, Visio Financial Services. It's some fraudulent stuff that has happened on the recorders, on the level of the recorder's office, because there's assignment. There are like 3 different assignments where, if you are MERS, you can't foreclose on the loan. You have to sign it back to the original or whatever bank so that it can be foreclosed on. Well, in the process of them doing that, which all took place after we had acquired the property, possessed the property, but they filed records with the Ohio Recorders, Hamilton County Recorder's Office, and 2 of them have identical hour, minute, and second stamps on them. And, what I've understand is that there is a process.
Well, Kim, just hold on. We're up against a break. Hold on. We're up against a break, so we'll get back to that in just a moment. My name's Marc Stevens, listening to the No Say Project here on LRN.FM. This is a quite different call than we usually get, so stay tuned. We got a lot more to get to in just a moment, so don't go away. Adverse possession. Sometimes colloquially, all right, I'm from Long Island, okay? Colloquially, or local... I can't say that word. It's that's how you know someone's really grew up in Long Island. They can't say colloquially. Jeez. Oh my God. Also described as squatters' rights is a legal principle that applies when a person who does not have legal title to a piece of property, usually land or real property, attempts to claim legal ownership based upon a history of possession or occupation of the land without the permission of its legal owner. In general, a property owner has the right to recover possession of their property from unauthorized possessors through legal action such as ejectment. However, in the English common law tradition, courts have long ruled that when someone occupies a piece of property without permission and the property's owner does not exercise their right to recover their property for a significant period of time, not only is the original owner prevented from exercising their right to exclude, but an entirely new title to the property springs up in the adverse possessor. In effect, the adverse possessor becomes the property's new owner. Over time, legislatures have created statute of limitations that specify the length of time that owners have to recover possession of their property from adverse possessors. In the United States, for example, these time limits vary widely between states, ranging from as low as 5 years to as many as 40. Okay, so that's the basic gist of it. And that is, of course, what you're what you're doing through the quiet title, of course, is to show that they have abandoned the property. Enough time has passed. You've done improvements on there, and that you should have title to the property. And so one or more of the banks were dismissed as defendants in this, but was it in the other one that's going to trial? Was the bank? It was a bank involved, and if they were they?
Yes.
They were, okay, and so they were not dismissed as defendants?
Not yet. We're in appeals court with that particular case. So it's not, pardon me, that's not one of the ones, the other one that is in trial.
Okay, well, for Ohio, are you able to show, you hate to do it, but are you able to show that the property has been abandoned for enough years under Ohio law for them to be blocked from claiming ownership?
Well, no, because here in Ohio it is 21 years
21
in order to get title. What we did was prescriptive occupancy conferred by operation of law. That was the basis for our quiet title. So what we were saying was we needed, through law, for them to prescribe the title based on the work that we had done. And we have a different situation here now based on securitization of loans. It was a point where you would take out a loan and it ended. It actually ended when you repaid the money. Well, now that process is just ongoing. It's just continuous. So the banks don't have interest, valid interest. They assume the position. No one questions it. So people are just evicted from their homes and becoming homeless based on something that's senseless. So through the quiet title process, in challenging the bank, the quiet title process itself says if you have whoever has superior interest, then that's the victor. That's the person that is going to end up with this title. Based on the fact that they don't have any interest that they can validly show, they're being dismissed. And I don't know. Had I known that they would have approached it from a criminal standpoint, I probably wouldn't have done it this way. I wouldn't have had my entire family involved anyway. But based on the fact that we were initiating something that was civil, and I thought all the civil laws applied, then I don't understand, how they're doing what they're doing.
Well, hey, one of the things that I wrote down early on in this was that, as corrupt as they are, even if it's civil, they could have saved themselves all the time, money, and effort to indict you, and they could have just had one of the judges or all of the judges, cite you for contempt of court, because of alleging that you were bringing, tampering records, and he could have just, contempt. We'll put you in for X amount of months. So just because something is criminal doesn't mean civil doesn't mean that they won't turn around and prosecute you, and indict you and do it criminally. There's no, it's the IRS can come after you civilly, and they certainly can then take the information they found and then use it for a criminal prosecution. And get so, wow, there's a lot going on here. So So you're using the improvement, you're using the improvements that you've done to the properties as a way to possibly overcome the 21-year abandonment rule.
And not necessarily. If that's not a possibility, based on how everything is going, then allow us to continue with the adverse possession process. At that point, we're still just adversive. But what they're coming up with in terms of these charges, they have the tampering with evidence. Tampering with records. It says no person, knowing the person has no privilege to do so, and with purpose to defraud, or knowing that the person is facilitating a fraud, shall do any of the following: falsely destroy, remove, conceal, alter, deface, or mutilate any writing, computer software, data, or record. The other charge, unauthorized use of property, computer, cable, or telecommunication property. A says no person shall knowingly use or operate the property of another without the consent of the owner or person authorized to give consent. The last one, theft, says no person with purpose to deprive the owner of property of services shall knowingly obtain or exert control over either the property or services in any of the following ways. 1, without the consent of the owner or person authorized to give consent, and 3, by deception. So, I don't see how that applies to adverse possession at all, to anything we've done through the adverse possession process.
Well, they have to give you some actual facts that they're using to support that claim.
Are those facts given after we're arrested?
No, it's supposed to be in the indictment. The indictment has to set forth, the indictment, just like any complaint, has to set forth sufficient facts to show an actual violation. And that's why I mentioned to you earlier in a motion to dismiss or motion to quash the indictment, I would put in there that the indictment is too vague and doesn't have sufficient evidence pled. It doesn't have sufficient facts pled. That's where I would start with this. This is. I'd like to actually see, if you can send me a link, I'd like to see some pictures of some of the before and after pictures. Because you're definitely going to have to document the improvements with more than just pictures. I mean, pictures is pretty good evidence, but you're probably going to have to show that that you laid out the cash. Did you know the 21-year rule in Ohio before you took? You did. Did you try to find how many years? How many years did you talk to neighbors and try to find out how many years it had been since it had been abandoned?
Yeah, we did all of that. We got all the information on how long it had been.
Well, how long was that?
Again, it varied from property to property. Like I said, the one had been, I would say 10. It's looking like 15, but just to be safe, I would say 10.
Okay.
We went and looked at utility records.
Okay, well, hold on. We're up against a break, so just hold on. My name is Marc Stevens, the website marcstevens.net. We'll be back with Kim in Cincinnati in just a moment, so don't go away. Yes, welcome back to the No State Project. Website, of course, marcstevens.net. If you are looking to learn how to effectively defend yourself, a proven method based on the Socratic method, reason and logic, not accepting sacred cows, always questioning. Go to marcstevens.net. We have scripts available. Also, templates, motion templates with instructions. You go to marcstevens.net. There is a link directly to the No State Project Skype chat, which has over 420 participants now, not all at the same time. And the reason why they're there already is because, like you, they are looking to defend themselves effectively against a bureaucratic attack. And we do role-playing, which is absolutely essential. So you can get that at marcstevens.net. Government Indicted, which has the whole model that has been used with more success on 4 continents. So definitely go to marcstevens.net. Check that out. We're talking with Kim in Cincinnati. And wow. So you knew that there was at least 6 years of... there was six more years before it would be considered legally abandoned, and that the banks or whoever abandoned the property, who had a deed to the house, would be legally prevented from even claiming ownership. But you went and you started making improvements there. Let me ask you, how were you able to get utilities on?
Well, in Ohio, all you have to do is call and say that you have possession of the property. You're either renter, tenant, or whatever.
Wow.
And
Okay.
they turn it on for you. And that's with the gas and electric. The water, you have to pay it in the owner's name. So you just pay the bill.
But if you were renting it from the owner, that's what you were doing. So could that possibly have been, could the utilities be something that may be under this umbrella of tampering with records?
Well, if you're not changing, you're just making a payment. You're paying the bill.
Yeah, I'll have to. I guess at this point,
Well, I don't
what I would be looking at is the two motions: motion to quash the warrants and motion to quash the indictments. One, you got a serious lack of evidence proving jurisdiction and a valid cause of action, and the indictment is too vague. It doesn't have nearly enough facts pled that you can determine one way or the other.
In terms of a motion to quash, what is the timeline on something like that, and how often or under what circumstances is that granted, or is it granted? Is that something that they even grant?
Well, I'm sure they get granted all the time. It depends on the circumstances.
Okay.
I would use the motion to dismiss as a template for the motion to quash the warrant, because it's all the same. We're raising the same issues. That's how I would get the ball going, Obviously, if a prosecutor or the police are going to talk to you, if they catch up, I mean, it's not like they don't know where the houses are. Keep your mouth shut. Do not speak to the police or the prosecutors regarding the merits of the case. I'm pretty confident that you will, and this is no slight against you, it's about them. There's really nothing you can say. They've already indicted you. They're not going to let you go. You can't talk your way out. Anything you say, they will twist and turn and use against you. So don't do it.
So do they actually have jurisdiction? Is it any way that they actually could have jurisdiction in a case like this?
I don't think that they can.
When it's the state of Ohio that is suing us, or whatever, bringing the indictment.
No, I don't.
Doing it under the
I don't believe that they can show any evidence that just because you're physically in Ohio that their constitutional laws apply. No, I don't. There's no way they can do that. I don't want to ever be 100% certain publicly. Anyway, I will say that there has to always be a possibility that it can be proven. No one has been able to do it yet. Now, I just have to, I always got to throw this out there. There is no state, and there's no evidence, the fact that their rules don't apply to anybody, that's not true just because no one to date has been able to prove it. Okay? I get that, that's a fallacious way of looking at it. It's not true, and it's because there's no evidence. We've examined it. That we know that by forcing strangers to give you money, that does not make written instruments apply and create obligations on somebody. So that's why that's true. Not because Kevin Shannon, who was a prosecutor there in Ohio, just because he couldn't prove the laws apply, that doesn't mean that no one can, or that no. So I always got to have that that disclaimer. I always got to put that, because I don't want anyone coming back and saying, "Hey, that's the fallacy." But yeah, I don't think I'm pretty certain that they can't. I've dealt with bureaucrats of every stripe. The best they can do is to say, like with Kevin in Brisbane said, "Well, we have these prisons." They could maybe say, well, you got these roads and you got this and you got that. Well, the Yakuza in Japan, they do a lot of nice things too. Jimmy Savile raised a hell of a lot of money for children's hospitals. Does that make him a good guy? Does that make him any less of a monster? No. So that's what I would do. And I would tell your family, anyone involved with this, not to talk to the police or the prosecutors. That should be the big takeaway from most of these shows is if you learn anything, don't talk to the prosecutor or the cops. Oh, and ask leading questions. That's a pretty big one too. Always ask.
So last thing, in terms of the timeline again on this, because we have jobs and different things, families we're trying to maintain, just expectancy. If a motion is filed Monday, it is not one of the writs, so it's not something that they have to see immediately. So how do you expedite that, or is it possible to do it?
The only way I know that you can expedite is you can file it as an emergency, and you can ask to have it calendared for a hearing telephonically. Because obviously, if you go in there, they're going to arrest you. Other than that, they're going to take their sweet old time, and they're going to get paid regardless. And there is no mechanism that I know of that can get a judge to make a judicial ruling in a certain amount of time. I mean, there are things like there are certain time frames given for habeas corpus, but you're not doing that. And I would point out that if you're going to do a petition for a writ, what would be most likely in your situation would not be a mandamus. It would be a petition for a writ of prohibition. Remember, only judges can issue writs. We're filing a petition for him to do that. So, but the petition for the writ of prohibition is going to be based on the denial of the motion to quash the warrant. Because the prosecution has no evidence to prove jurisdiction, and the judge is going to go forward anyway. And the prohibition, for those who may not be familiar, is an order from a higher court to a lower court prohibiting that court from acting outside of their jurisdiction. So that's why that would be the appropriate mechanism if, in fact, the motion to quash the warrant, and the motion to quash the indictment is denied.
They have another person that they've also included in this criminal case. Her record or her case has been consolidated along with ours, and we don't know this person. So, and I guess in his head he's trying to create this scheme, and he's like just lumped.
Wow. Well, I would recommend. I would, before we're out of time, I would recommend that you don't discuss the merits of this with them.
Yeah. Yeah, I kind of felt that way.
Just treat them as a jailhouse snitch. Hey man, it's nothing personal. I got to protect myself here. I don't know you from Adam, and I am not discussing the merits with you. So that's what I would do.
He had $100,000 bond straight.
Holy crap!
In fact, according to the record, she's incarcerated, but she had priors. None of my family have any, prior history with criminality or anything else. But she's had theft before, doing something with credit cards. She's done some things. So I was kind of hoping maybe that $100,000 straight had to do with that more so than what we're doing.
Well, more than likely, that's a pretty steep order there. So she must have some really bad. She must have some pretty bad. That's not good. All right. Well, we're pretty much up against the top of the hour break. So I appreciate your call, and
thank you
keep me in the loop.
I'll keep listening. Thanks. Bye bye.
Thanks. Appreciate the call, Kim in Cincinnati. Oh man. Yeah, and that's the thing. It doesn't. This is not something that usually comes up very often on this show, especially that they've indicted someone that you don't even know. Do not speak to them. Always treat them as a jailhouse snitch. They're just going to feed the information to the prosecution, and it's better to be safe than sorry, because you don't even know them. But man. More reason, you know. It's like I can imagine if private people were improving the water in Flint, Michigan, that they'd be prosecuted for that. Actually improving the neighborhood. So, and that's, well, who would have thought? All right, well, we'll keep track of that. Hopefully, we hear back from Kim real soon, and we get an update as to what is going on there. I think we have another caller. Well, we're going up against a break here in any moment. So, but it looks like we have another caller from Cincinnati, so we will take them next. But if you do want to join me on the big show, well, they just dropped off. Okay, well, I think we have New Mexico that will start the show, the third of 3 hours. What is wrong with me speaking today? The third of 3 hours of Anarchy Radio right here on the Liberty Radio Network. And by anarchy, of course, no rulers. So I watched something the other day, and it's a very popular commentator and news saying, that trying to equate anarchy with no rules. That's not anarchy. That may or not be mayhem and chaos, and they're not synonyms. They're not the same thing. Anarchy meaning no rulers, not no rules. We believe in that the basic principle of do no harm applies to everybody across the board. So we do not excuse any from that. And I'm pretty certain that we are off air, but we should be at the top of the hour break. So we'll be back in just a few moments. Don't go away. Welcome back to the No State Project. I'm Marc Stevens. The website, marcstevens.net. And it's November 25th, 2017, live from the fortified compound in Mesa, Arizona. Glad to be with you here today. The number is 218-632-9399, 218-632-9399. You want to join me on the big show. The passcode is 2020 with the pound sign, so 2020 and that there hashtag will get you into the queue. And Skype, it is Frank Rizzo 3. It's Frank Rizzo with the number 3. Instant message me first, and then we can get you on the big broadcast. It looks like we have a new caller from New Mexico. Area code 505. You're live on the No State Project. What's your name? Where are you calling from?
It's Kerry.
Whoa. Hold on. Say that again. I'm sorry.
My name was Kerry.
And you are calling from New Mexico?
Say that again.
You're calling from New Mexico?
Well, I'm calling from my phone. I've never been in New Mexico in my life, but
okay.
As you refer to the area code 505.
Oh, okay. Well, where are you calling from?
I'm calling from my living room.
Well, I didn't need you to be that specific, but we'll just put you down. And it was Carrie?
Well, yes, sir.
Okay.
Hey, Mark? Mark?
Yeah.
I need your help, boss. I'm in deep doo-doo.
Okay, I'm sorry to
with
hear that.
The government. Pardon?
I'm sorry to hear that. What's going on?
Well, I have a neighbor, and my neighbor and I have an easement dispute, and when I purchased this piece of land, the neighbor to the north gave up a 25-foot easement, and the neighbor to the south gave up a 25-foot easement. And back in 1986, he signed an agreement to that with the surveyor and one of the neighbors and the person that subdivided the land. And my neighbor started blocking off the easement. And once he did that, he could no longer receive his mail. So he put his mail in the middle of a county road in an intersection. And once he did that, that kind of cut down, obviously that's cutting down my access egress onto my land. And then he left a drag or a float in the middle of the county road.
He left what?
A drag, a float, something that you would put behind a tractor.
Okay.
So once he accomplished that mission, I drove around the float to the west side of it the next day, and then the next day he took a vehicle that was registered in 2004 and he parked it there. So then the next time I came through the intersection, I had to back up because by then he'd already damaged my truck from my driving over the obstacles that he'd placed in the roadway. And upon backing up, I ran over his mailbox, which he had placed into sand, which he had burned maybe 3 or 4 foot high in the middle of a county road. But furthermore, attached to the mailbox was a stop sign, which he arbitrarily decided that he was going to, let's just say, be the new sheriff. But on top of that, he's got a traffic signal at that intersection too, which is his. It does not belong to the county, state, government, or it is not their possession, it is his. So lo and behold, he's got video cameras up there, so he calls the government, and then they file a criminal complaint against me. And my situation being is I have to look at the government as a third-party intervener in between his claim.
What's he claiming?
But
What's the charge?
He's not claiming anything. The state's claiming that I damaged his property. But yet I have photographic evidence there's no damage to his mailbox. Well, lo and behold, I've read some of your stuff from the last 10 years ago, and I have some 100 matters that have pended in the court cases regarding zoning issues. So,
jeez.
All of a sudden now I'm getting letters that are 4, 5, 6 years old on matters that were settled where the government's coming after me for more monies because they feel that they're just entitled to it. So somewhere in all your writings and everything, and I apologize that as I'm going through my life, I'm a general contractor. I have my own business, and I really don't have the greatest amount of time for studying judicial issues, but I certainly believe in my family. I certainly believe in my life, and I want to protect my family. I want to protect my life. And somewhere in there, you have some literature where one might just go into a courtroom and just ask questions. I used to have some literature from you where I had like 50, 60 questions on paper.
Oh, sounds like you had an old script.
Well, it's like I said, this is from like 15 years ago. And anyway, somehow or another, the thing of it is, Mark, you cannot be from Arizona if you are from your mom and dad, you know? Well, you can't be from New Mexico if you're from your mom and dad.
But that's not what I was asking. I was asking about your physical location, and I usually talk in lay terms. So I was born in a hospital in Cheektowaga. That's a fact. It doesn't mean that I'm part of some political organization or anything like that. That just happens to be the physical location of my birth. So if you're talking progeny and you're talking family, yeah, I come from from parents and grandparents and whatnot. But that's when I asked you initially, which I thought your response was great. It's actually part of the record now on the caller line. I didn't. Just for everybody, when I ask where you're calling from, I mean physically, geographically, with no kind of political connotation at all there. But it sounds like you have a script, an older script, which based on experience, we learn and we adapt and we get better. So the script has changed quite a bit in 10 years.
Well, it may be older than that, Mark.
Oh, wow.
And I'm telling you, boss, I've always looked up to your works and efforts in high esteem and regards. But I'm telling you, the government is coming after me. Like, I have a written order from the district judge. Anytime I walk into their courthouse, I will be escorted by no less than 2 deputies.
Nice.
I've had the zoning officials attending children's court because my daughter was my daughter was accused of doing something that she didn't do, and because that she didn't do it, I knew in fact that she didn't do it because, well, I'm her father, and my son did graduate college valedictorian, and I come from a long line of sternness and steadiness that, and we're not trying to make trouble for ourselves, but how in the heck does one in these days and times keep from being ambushed by a government that all they want to do is take your money? And then one of the things that, I've watched here recently where...
But let's stick to let's try to stay focused here, okay? It's been a while since you've probably seen the material, and what we do is always start with a motion to dismiss and ask for, discovery to get the ball rolling. As far as the merits of this, it's not something we want to discuss until jurisdiction is shown, or you believe that you've got sufficient leverage over the prosecutor that you can then bring your ace in the hole card, being the photographic evidence to show that there wasn't any actual damage that was done. But we're up against a break, so I'm going to have to mute you up. We'll be right back. My name is Marc Stevens. You're listening to the No State Project here on LRN.FM, the Liberty Radio Network. 3 hours of anarchy radio every Saturday, and also live this Wednesday for the Wednesday broadcast, which is a video stream. We'll be back in just a moment, so don't go away. Okay, I welcome back, Carrie. I was just reading something, and apparently it didn't go over the air. But I was just reading something here on Wikipedia that when they were doing the 505 area code back in 2001, that the agency responsible for doing that had some pretty vocal opposition and even death threats for changing an area code. So I didn't. I've never heard of that before. So, ooh. Okay.
Well, there are a lot of people that have 505 tattooed to their forehead, so you can almost imagine they'd be disappointed.
Yeah, but the thing is, if I want to see face tattoos, I usually go to San Bernardino. I don't, New Mexico doesn't strike me.
There is that percentage of the population that they actually believe that that's where they live or whatever. They don't understand that, in fact, the only thing that Mr. Stevens could ever be is a Stevens. You cannot be from Arizona unless it's by your opinion. In fact, you're a Stevens.
Well, are you getting into some kind of Freeman type or sovereign type?
No, sir.
Okay.
I'm not. I'm certainly I'm a true believer in life and liberty.
Okay. All right. Well, let's get back to the. So now that the tech issue is solved, which is it's between the keyboard and the chair, or the keyboard and anyway, it's my fault. Are you familiar with the motion to dismiss and how we go about challenging the prosecution's claims?
No, that's why I was calling. Is because I need to take some action. I have taken in the approximate of some 200 photographs of this ongoing dispute between myself and the neighbor, and it started back in July of 2016, and it's only escalated to the point where we're at now. My neighbor has pretty much injured me fairly significantly by leaving the drag in the road where I hit it, and then obviously when I missed the drag the second time, I ran up onto it the second time after he moved a vehicle where I was using access to the county roadway. When I backed up onto the berm of dirt, that didn't do my body any justice either. But even before that, on the private roadway, the man had dug like a lion's pit, to catch tigers, but it was actually to catch my vehicle, which is like I said, I own my own business. The gross weight vehicle of the particular vehicle was a 33,000-pound vehicle. So, I certainly have a neighbor, and one of his advantages of his life is his son's in the sheriff's department.
Oh, so that's never good.
Pardon?
That's never good. When there's a cop in the mix, it's never good. I would recommend the way looking into, and we can discuss the motion to dismiss to at least address the issue of the court filings is proven to be effective because we're using just basic principles of logic that the prosecution bears the burden of proof. And so we take advantage of that. They have to prove every element. They have to prove their claim is true. And the bottom of their claim, the foundation of their claim, rather, is always the same thing. You're physically in New Mexico. Our rules apply, including their constitution and their code. They're accusing you of violating their code, which is the authority for that is the Constitution. That's where we focus on that. And we know that they can't prove that, like I've mentioned on the show earlier already, because they're just men and women. There is no government. They're just men and women forcing us to pay them. And and that's why that forms the basis of the motion to dismiss. Obviously, there couldn't be any evidence showing that there's a valid cause of action for the court to take subject matter jurisdiction because it's a code violation. So it's not just that they're accusing you of violating the code. They are stating that the code applies to you. The full... Really, if you don't delete any of what's really happening, is they're saying our laws apply because you're physically here in New Mexico and you violated them because of this. And there's no evidence to show the first part of that. It's just a claim that they're making. So that's the basis of that.
But one of the things, because they seem to wiggle past whatever I do, and then the next thing they're going to claim is it's damage under $1,000. Well, their dollars are not American dollars. They're Federal Reserve notes. They don't have any money.
Well, that's really not something that we need to get into to address here, because the damage, all right, you have injury and damage and redressability. I know that was really bad English, but you have injury, damage, and redressability. That's what you need to have a valid cause of action. You don't always have to have damage, physical damage, though, to have a cause of action because you could have trespass. But there has to always be the violation of the code. And to violate the code, there has to be evidence that applies to you in the first place. So they don't even have it. So without even looking at the damage, you can knock out their valid cause of action just by taking out the foundation that there is no evidence to show that it applies in the first place. And they may argue and say, well, we don't have to prove that. And I talk about that. They're not going to let you do that. So you have your obvious double standard. Plus, it's prosecutorial misconduct to argue without evidence. I know you have a lot to get to, but I'm running out of time. So just hold tight. My name is Marc. We're up against the break. We'll be back in just a moment. Don't go away. Welcome back to the No State Project. Yes, I unmuted that time. It's November 25th, 2017, live from the Fortified Compound in Mesa, Arizona. Remember, May 3rd through May 6th, 2008. Libertopia. Go to libertopia.org. Welcome back, everybody. We're talking with Kerry in his living room. And so welcome back, my friend. I think we were leaving off where we're trying to walk you through the process of defending, at least again, and trying to remedy the court complaints. So how many complaints are there filed against you in court that are criminal?
Right now, I have the one criminal complaint, and then I went to court several times, and no one showed up, and then I motioned for dismissal, but then they had 90 days to refile, and the district attorney came in there and refiled the case, and somehow or another, due just lack of inexperience, reading, knowledge, I've not been able to file the right kind of paperwork that would stop it. And I did ask, like, for the neighbor had documented all this on video, that I asked for the video. And then, of course, the judge refused my warrant for the video.
Your warrant?
But
when we go into these courts, unfortunately, we don't have to know a whole lot of jargon, but we have to know some of it. And if you want a copy of I mentioned this earlier, If you want a copy of this evidence that they're planning to use against you, which includes videotape, you have to file a discovery request. So you want disclosure of what...
Well, no, I have all their discovery. Now, what I wanted from their witness, because their witness had video cameras over that neighborhood, and as I stated, that my situation went back for a year, and I've caught my neighbor moving the surveying pin. You know what I'm saying? So I certainly just, how in the heck can a living person have rights over a county road intersection, you know, other than the fact that his son's in the sheriff's department?
Well, that's going to say a lot for that. That says a lot for that situation. I mean, every time I get one of these calls from somebody that the court is bending over backwards to do as much damage to the victim, especially if it's domestic violence, I always know when I hear those stories, it's a very, common pattern that I say, well, is the ex or is the abuser a cop? And almost every time, well, yeah, how did you know? I'm like, well, but yeah, cops are a privileged class. There is privilege. I'm not saying white privilege, but there is definitely blue privilege. There is a privilege in being one of the king's henchmen. Yeah. Ken Anderson, that it's privilege that judges get, if prosecutors or judges go to jail, it's for 10 days instead. They could put innocent people in jail and only get 10 days, if that. In fact, Ken Anderson was the first prosecutor in American history to ever be punished with jail time for falsely convicting someone. But okay, so I understand a little better now. So the prosecutor isn't planning on using that as evidence against you. So it's not discoverable from the prosecution, but you believe that this tape exists and you should be able to subpoena that. The court should subpoena that.
Well, when in fact that you have a person that's pulling up a surveying pin and moving it over 1 foot, because basically, like I said, this guy entered into agreement because he claim jumped on the northern boundary between him and the church, where he took this extra land, and then the church went after the man that created the subdivision. And our plat of land over here is the redevised agreement because of his stealing land. And then, of course, obviously, when he came out here, 20 years ago into this part of the outbanks of Albuquerque, that he claim jumped, and probably when he set up his fences, he put them on the opposite side of the boundary, so that's why he would move that one boundary pin. But he's already claimed that the 25-foot easement, which grants me access to a county road, is null and void, because other than the fact that, well, he bought the land, but he doesn't have to abide by, obviously, the easement agreement, which he signed back in '86, and mostly because he is the sheriff in his own mind. His son works for the sheriff's department, and he is the law. And, by God, he can just go out there and in the middle of a county road, put up a federal mailbox. At the intersection, he's got his own traffic signal. And, when the policemen come out there and they got the video that they got from him, the policemen have to overlook, they have to, never mind the fact that he's got the float in the middle of the county road, never mind that he's got the truck parked in an intersection where most municipalities, counties, whatever, going to say that you have to park a vehicle 25 foot out of an intersection to allow people, access and egress, and basically you don't want to leave.
Yeah, but Carrie, I don't have much time here. What we have to do is focus on getting this complaint thrown out.
And I apologize for my rant, Mark.
No, it's fine. It's just I have a line of callers too, so I can only go. We only have what's left of this segment. Someone
that I can get in contact with you.
Well, yeah, you can
contact after the.
Well, sure. It's a markstevens@mail.com, and you can get me that way. Yeah, mail.com, and so I'm very. I don't like the idea of having to use a subpoena to get evidence. I mean, have you spoken to this person who claims to have this video evidence? Have you spoken to them about getting a copy?
he's threatened us. Well, when we served him with the warrant, he tore up the warrant. And, I apologize. When we served him the subpoena, he tore up the warrant, came running out. We have to pass his house to get out to the county road. And then he, come up to the passenger side of the car, because he's obviously, as we travel by, he's on the right-hand side of the road. And he's throwing that. But this guy runs around with his pistol and his rifle. We don't know if he's going to kill us or not. He's already suggested to my significant other that he's afraid that I would shoot him. And the thing of it is, Mark, is there's only one tyrant in the neighborhood that runs around with guns. I've never, in the 12, 15 years, possessed a gun, let alone made any kind of those kind of threats. It's just not the road I'm going to go down in life.
Well, but why were you trying to serve a subpoena?
Well, I had my son do it. I can't serve a subpoena, but I can have somebody do it for me, and I had my son serve it to him. And we were leaving.
Yeah, that's a bad idea.
To go take care of some other business, then he saw that we had come back, and then he ambushed us at roadside. Yeah,
you need to avoid contact with this guy. This is bad, and you shouldn't even have your son doing it. It should be someone completely disinterested in what's going on. So in that situation, it's worth, because now he can claim harassment. Because you were with him when he was serving it?
No, sir. Oh. My son had served the warrant earlier in the day, and then 20, 30 minutes later, we needed to attend to some other business in town. We went up the road. I'd forgotten my phone or whatever it was, that we turned around, we left, and as we're coming back up the road to go back out is when the man ambushed us.
Oh, wow. Okay, so
and this was... Like I said, he also ambushed my wife at that same intersection. You have to go past his residence in order to get to the county road. This is the same guy that has blocked off half of the easement. Now, I happen to have some 40-foot beams, and obviously I can't on a 25-foot intersection, because he's blocked off the private road and he's blocked off the county road. I can't access or egress my land.
Wow. Okay. Well, I have to mute you up because we have to go. We're up against a break. You'll have to contact me off air for further help, and I'll call the Wednesday broadcast. My name is Marc Stevens. We'll be back in just a moment. Don't go away. We are in the last hour of Anarchy Radio here on the November 25th edition of the No State Project. We will be live on the Wednesday broadcast. That's on my YouTube channel. So if you're not subbed, do it so that you'll have the notification when we're going live. But it will be at 4 p.m. Mountain Standard Time there on the No State Project YouTube stream. So whoever we're not able to get to today, you know the drill, will get to you on the Wednesday show. The Wednesday YouTube stream without commercials. So check that out. I want to get back to our calls. This is the last segment. We've got Mr. Black from Pittsburgh. Welcome back to the show. Mr. Black. Okay. We'll try him again shortly. Wow. All right. And we got Kim back in Cincinnati. Maybe Kim, welcome back to the show. Did you have another question? Okay, now there's something wrong.
I'm sorry, I was listening.
Okay, you're just listening?
Yeah.
Okay, I'll mute you back up. We're going to try Mr. Black again. This will not be part of the podcast. The great thing is I get to edit all this stuff out. We've got Mr. Black. You're on the No State Project again. Wow. Okay. Well, maybe he's just listening. We'll mute him back up there. I guess we could have kept Carrie back on. No big deal. But we're in the last segment here, and one of the things we was talking about before, we were talking about the straw man fallacy. And so, if you remember back from the beginning, of the broadcast today. We had filed a motion to dismiss. Well, not we, but Zia had filed a motion to dismiss in Jersey, and the judge had come back and said he doesn't agree with his interpretation of the Constitution. And this is kind of a variation on a straw man theme. And for those just tuning in, again, remember, the straw man is where you raise an argument or you ask a question, and instead of answering the question or addressing your actual argument, they create, or they make one that sounds similar, but isn't actually addressing your actual argument, and so that they think that they're knocking down your argument or defeating your argument or knocking down the straw man. It's not the same thing as the Freeman sovereign types talk about with the straw man with the only cap. So we're talking about the logical fallacy of the straw man, and this is kind of a variation on the distraction or the tactic used by tax agents, that you're debating the constitutionality of the laws, or that you're arguing constitutionality of the code. No. And what we need to do there is we need to just object and get people back on point. That's not, and you do that not by telling them, but by asking them. So you can ask them point blank, at what point in time did I actually challenge your laws as being, the constitutionality of your... In fact, why don't you tell me what particular laws I'm challenging the constitutionality of? Because if you go through all the Call of Shames, you'll notice I don't typically talk about a particular law. It's not a particular law in question. And we never challenge constitutionality, even if we do cite a law. What we're doing here, regardless of minor disagreements that we will with some critics, we are not challenging the constitutionality of the code. We're not even challenging the constitutionality or validity of the Constitution. We're challenging the claim made by the tax agent. Now, it's been argued, well, Mark, you're an idiot. If you do challenge the application of the Constitution, if you are challenging someone's claim that the Constitution applies, you are challenging the Constitution itself. And no, I'm going to have to say no. There is a world of difference between challenging the Constitution and challenging a police officer's claim about the Constitution. That's why we're able to almost universally get the police officer declared incompetent. Of course, we have some very few exceptions, Jermaine being one from last week, where in his cross-examination, the prosecution did not declare their witness incompetent through an objection, which is extremely rare. We usually get that. But these are two separate things, and what do you call that? Conflating? The idea is just laughable on its face. I mean, why not extend that even further? Why not just turn around and say, reminds me of Braveheart. An attack on one of the king's men is an attack on the king himself. So why limit things? If the cop is saying I violated the law and I challenge that, why don't you say, well, then you can't challenge the validity of the law? You can't, No, when someone makes a claim, regardless of who they are, it doesn't matter who they are. If they're making a claim that XYZ is true, then they better pony up some damn evidence. They better have a logical, valid argument to show that. And if they don't, regardless of who they happen to be, it doesn't matter. That's why I keep going back to that video that almost nobody has seen of Scott Bales. And he's the Chief Justice of the Arizona Supreme Court. I mentioned him earlier because he was the most prominent one that I've spoken to regarding evidence that there are constitutional laws apply to us just because we're physically in Arizona. He said on video, I'll have to post it again, that the facts proving that the laws apply to me because I'm physically in Arizona is because they prosecuted and put other people in prison. Which was, of course, parroted by Bill Montgomery, the Maricopa County attorney. He's the district attorney, the county attorney. He's the chief prosecutor. No. It's funny. You should want to always question that. I mean, it's such a stupid thing to say. That's why they have to come up with these straw man arguments. That's why they can't address it head on. Because the only thing they can come out with is these stupid things. They put other people in prison, which is why I mentioned Marc Dutroux and some, a lot of these serial killers having their own prison. I mean, can you take someone serious when they're trying to show that the basis of their legitimacy, the only thing that separates them from a criminal on the street is their prison? You're going to have to do a little better than that because, like I mentioned, most serial killers have their own prisons. That's the key to legitimacy? These are the types of people we're talking about here? These are the ones that are revered to this day? That their henchmen are given an automatic free pass on credibility? And it doesn't matter how many times these people are shown to be criminals? I mean, even just outside of their regular job? That there was a Sergeant Watt or Watts in Chicago recently? Wow, a cop going to prison. And there's not that much online about it, not too much information that I was able to find, but definitely check it out because if 15 people have been exonerated, which is amazing, because this cop was running a racket in addition to his regular job. 15 people he planted drugs on, that people in the neighborhoods knew if you don't pay Watts his money, you will have large amounts of drugs put on you, and you will go to prison for a significant amount of time. No matter how many of those stories come out, people still give a free pass to this criminal organization. That, well, it's your word against the cop, and the cop is automatically given a presumption of correctness. You know what I say to you, presumption of correctness? Fungal. That's what I got to say about that. I appreciate everyone tuning in. We are totally out of time for this November 25th edition of the No Stay Project. I will be live on Wednesday on my YouTube channel, No Stay Project. So till then, salud.